Okay, so thanks again for attending this webinar. We should be done in about 35 to 40 minutes maximum. I'll make sure there's time for questions at the end. Please do type your questions in as we go along, and please forgive me if I don't get to them immediately. If it's relevant, I'll try and get to it straight away. If not, I'll save them for the end. So the reason you're here probably is that this is a bit of a thorny issue, both in social care and special education. And it's about how we stick to the legislation and what we really should be doing for our learners who use AAC. And when I'm talking about AAC, I will talk about paper-based, or often called low-tech AAC, as well as high-tech or digital AAC. So I'm going to start you off with a story, and it's the story of a lost iPad. And this is a true story, I'm afraid to say, but this shows you what might happen in this sort of situation. So this is John. That's not a real picture of John, as you might be able to tell, but John's an AAC user. He uses an iPad, and he accesses an awful lot of communication through that. John also likes to go swimming. And John took his iPad to the swimming pool because he needed it to communicate when he was getting changed with people on the way and things like that. Obviously, he didn't take it in the swimming pool. John took his iPad and he put it into the locker when he went into the pool. But some of you might be able to notice that there's something wrong with that locker, and that is that the door is open. So somebody stole John's iPad from the locker while he was swimming. And obviously this is annoying for John, highly annoying in terms of losing his voice. It's also, there's a financial implication there, but the biggest implication really that we're thinking about today is all of that data loss. We can replicate that for John. We can create him another language pack on an iPad, but the data has been lost. And once the data gets lost and that iPad belongs to an organization, that's when the issues start to occur, because GDPR kicks in. So it'd be good to have a think about what data might have got lost. So whether you can predict a lot of these things, it's pretty easy to think about. There's a lot of first names on that device. John had a lot of contacts on there, a lot of pictures, sorry, of people that he spoke to, people he needed to refer to, and that generally had their first name and their photo. It also had John's age and his birthday on there, because he liked to talk about that. And it had the school that he attended before he went to college, the town of residence. It had his current place of education on there. It had names and photos of other students at his current college on there, names and photos of staff on there. So that's an awful lot of data there just sitting, and it's not critical data, it's not highly sensitive, but some of it in combination could be seen to be sensitive data. If you know a lot of that information about someone, then you can find out an awful lot more about them from that. So what we have to think about in terms of GDPR is the total number of individuals that impacted. Because this was a data loss, it had to be reported to the ICO, the Information Commissioner's Office. And they ask the question, whenever you report a data loss, how many individuals have been impacted by this? So back to our list that we had there, we're thinking of names and photos of other students and names and photos of staff on one iPad. I'm just going to give you a couple of seconds to make a prediction in your head about how many individuals you think that impacted. And the answer is 117, just from one person's communication aid. Now, that might be a low number for a lot of people who use electronic communication aids. It might be a lot higher if you think of the amount of peers and professionals that people come into contact with. There might be an awful lot more than that on there. But for John, that was 117. And because of that, the Information Commissioner's Office suddenly got interested, because there wasn't a massive amount of types of data on there, but there was a massive amount of individuals. What that also means is that the organisation involved has to send out 117 letters, physical letters, bits of paper, to the individuals who were impacted, and say to them, some of your data has been lost in this incident. Now, while we're on this subject, it's really critical that if this does happen to you and you have to send those letters, be specific about the type of data. I think it would be self-defeating to send out a letter that says your data has been lost, because people start to think it's things like their national insurance number or their passport number and things like that. It's not. Be specific about the type of data that's been lost, and most people's response will be, oh well, that's on Facebook anyway, so what does it matter? However, legally, they still do need to be informed. So why should you be bothered about this? I've looked at the attendance list for this webinar, and there's an awful lot of people in an awful lot of different job roles. But the reason you should be bothered about this is twofold. This device does belong to the organisation if you're lending it out to someone. If it belongs to the individual, this doesn't apply, but we still should think about it, as we'll discuss later. But if it belongs to the organisation and contains data which may result in a risk to people's rights and freedoms, then you are covered by GDPR legislation, and loss of that device or loss of that paper is a personal data breach, because it contains personal data. All those data breaches must be reported to the ICO within 72 hours. Now, as we'll discuss later, you need to find out first whether it's a data breach or whether it's considered a data breach before you do it. But this is the summary of the GDPR legislation as it applies to organizations, devices owned by organizations. This is a really long way of saying this is the letter of the law from the ICO, Information Commissioner's Office. And really what this rather long statement is saying, it's considered a data breach if it results in physical or material damage to natural persons, or a limitation of their rights. So if somebody can take that data and do something with it which influences a person's natural rights, so if someone takes that data and they take out a car loan, or they pretend to be that person and fraudulently undertake a transaction, then that's that has implications for that person's rights. And because of that, your organisation could be prosecuted. So you should be bothered, because the fines under GDPR are massive. And this is the big difference. This data has always been protected under law, but the fines now are really, really high, and organisations could really, really suffer from this. Now, this is what they state as the fines. It could be up to 10 million euros, or 2% of the firm's worldwide annual revenue. And for those of you that think that, well, it might not matter anymore because we're exiting the EU in the UK, well, chances are that the UK data protection law will roughly mirror the EU law, or it will for a time anyway, so it's going to roughly apply. So prosecution is one reason why you should be bothered. Because of this law, your organisation could get fined. But you should also be bothered because it's a matter of respect. We should be treating other people's data in the same way that we would treat our own. What your granny always said, do as you would be done by, treat other people like you would like to. And this applies to data as well. If you're going to be careful about your own data and you don't want it to get out into the wild, we should be doing that with the data of the people that we're supporting as well. Beaumont College, where I work for half of the week, have developed, due to this incident that I've previously mentioned, that really happened, developed a process that refers to data and AAC. And as with all these things, it's specific to Beaumont College's setting, but I think generically it applies. And I'm happy for you to take this as a template and apply it to your own organisation. And if you've come up with a better way of doing it, please let me know. So I'd really appreciate that. But this is what we do now at Beaumont College. This looks rather complex, but I'm going to just zoom in on it for a sec and go through it step by step, so you can see it. So we start off with the first question in this process, and this is, does the communication aid, and when I'm talking communication aid, I'm talking paper as well as digital, does it belong to college? Excuse me, or does it belong to the learner? So that's our first question. So if it belongs to college, there's a long process. If it belongs to the learner, then you can see it's not covered by GDPR. But what we say is that good practice would involve following the process as set out below, as though it did belong to the college. Because bringing us back to that earlier point about respect for someone else's data, we need to make sure that we're doing the right thing by the individual. So even though the communication aid doesn't belong to the learner or the individual, it might be that you're influencing that process. You're putting photos onto it, you're adding text, you're adding information, and therefore you still do have, I would call it, a moral responsibility to make sure that good practice is followed. Okay, so that brings us on to the question, if we say, right, does this belong to college in our case, or does it belong to the learner? Well, if it belongs to college, then we're thinking about, is it high tech or is it low tech? And let's deal with high tech first, because I think that relates to our story from earlier, so it's a bit more tangible. We think about high tech and we say, well, first off, have all the relevant processes been followed? Number one, has it been inventoried and has the serial number been recorded? If you lose your phone, or if you lose any piece of technology and you report it to the police, as you should do, then the first thing they'll ask you is, have you got the serial number? Because it needs to be recorded as a crime and the maximum amount of information needs to go down in the record. So you need to have a good inventory process in place. Then at Beaumont College, we also ask, has the device been set up on MDM, a mobile device management system, so that it can be locked and wiped remotely? Now, if you don't know what an MDM is and you work in an organization that loans out devices, then you need to find out pretty quickly. But essentially, it will mean that you can have remote access to that device. It can be locked down. If you've lost it temporarily, you can lock it. If you know that it has gone and has been totally lost, you can institute a remote wipe, which means the next time someone connects that device to Wi-Fi, it will just wipe all the data off it. They'll still have the hardware, they'll still be able to take it, sell it in the pub, all of that sort of stuff, but they won't be able to get to any of that data. And if you report that device as a data breach to the ICO, that's one of the first questions they're going to ask. Have you got a means of wiping that data? Often it's called a remote wipe, or an organizational control, or that kind of thing. But normally all this comes through having an MDM, a mobile device management system. And this applies to iPads, Android, you can do it on Windows devices, you can do it on phones, all of that sort of stuff. So that's question 2, and we're making sure all that background work is done before this thing even gets in the hands of the person who's going to use it. So thirdly, is there a way to lock the device, i.e. put a lock on the device, or screen lock, that won't interfere with its functional use? Now, for most people using AAC, using high-tech AAC, the answer to this really is going to be no, because if you wanting to communicate using technology, and you have to put in a PIN, a 4-digit PIN or a 6-digit PIN every time you want to say something, there's a clear and obvious barrier to your communication there, and we don't want that in place for most people. There are options out there, obviously, as you can see, you know, for an iPad, you could have a PIN, you could have a fingerprint code on a lot of devices now, and on some you can have facial recognition as a way of unlocking. Facial recognition is probably the least intrusive because just looking at it will unlock the device, but it's by no means foolproof, so it might still provide a barrier. However, if you haven't put that barrier in, if you haven't put that lock in place, you need an assessment and a clear and written rationale that gets recorded as to why you didn't do that. Because again, the ICO will ask the questions of, well, why wasn't it locked? Once you've locked a device, it becomes encrypted. So if you've got an iPad and you put a PIN code on it, that also applies an encryption. So the data can't be removed from that device without that PIN being known. If someone repeatedly puts in the wrong PIN, eventually the device will get wiped, or they need to wipe it to unlock it. So again, important that you record that so that you can show you've undergone due process. So moving on to number 4, and again, all of these things are important before we're even talking about what goes on the device. Are all staff who might be working with that individual aware of the procedure should the device go missing? So bringing us back to number 2, if we want to remotely wipe that device or lock it, we need to know as soon as possible when that device has disappeared or can't be found, even if it's only temporary. So all people, it might be this might be the individual themselves knowing this might be the staff around them, or both, knowing that as soon as, in our case at Beaumont College, it's a way of saying as soon as you think that device can't be found, you need to ring college and you need to tell them that. Because the ICO will also ask you the question of how long was it before you knew that that had got stolen. So they're looking at the risk factor, and the risk factor is that time between loss and it getting remotely wiped, or the command getting sent to remotely wipe it. If that's a period of a short period of minutes or hours, that is favourably looked on. If it's a period of days, then they're going to say, well, how come that data's been in the wild that long? What was the problem there? And then that's when they start looking more in depth. So with all that in place, we also then need to think, is all the data going on to that device necessary and functional for the learner's communication? Now, this becomes a bit tricky because we need to make sure not only that the information and data on that device is there for what the learner or individual needs at that point in time, but what they might want to talk about. And we don't want to limit individuals by just saying, oh, here's the things we know you want to talk about, so we're just going to stick with that. I totally understand those issues, and I'm aware that some people are probably shouting at the screen and saying we can't limit people, and I understand that. But when it comes to the organization, again, you need to think about the information that goes on and not just chuck everything at it, and record your rationale for doing that. If you're putting a lot of data on there that learner or individual doesn't use every day, you need justification for that, and you need to have this written down. So we also need to think about, and this again, this applies to everyone who uses AAC, not just organizational devices. Do we want that sensitive data to be on there? Is that a risk? Now, again, this might be a discussion that you have with the person using it. Do they want their full address, their date of birth, their photos and their religion? This is all sensitive data. If they don't need it on there, their full address, they might want town that they live in, which is a lot vaguer. And they might want their day and month of birth rather than the year as well, then only include that data if it's necessary. And again, reminder that this applies to paper just as much as it applies to digital. The other thing that we put in place at Beaumont College is we've said there's a limited range of people on devices that belong to the organisation who are able to edit the language pack. And this is to make sure that lots of data doesn't end up on that device that is not necessary and could lead to massive amounts of data loss. So in our case, it's the speech and language therapist, the speech and language therapy technician, the assistive technologist, and probably if that person has a lead tutor that they liaise with. Generally, for us, well, all of that goes back through the SLT anyway if there's a decision to be made. But it means, again, there's a process in place and we can tell the ICO, no, it's not just anyone who can chuck anything on that device. So let's move on to low-tech devices. That's pretty much the same process. But you're cutting out all of the background stuff that needs to be done about MDMs and things like that. Essentially, it's down to all staff being aware that should that communication aid, that book, that sheet, whatever it is, go missing, then everyone knows that they need to report that. And they need to take care of that before, so that to prevent loss. Obviously, the person needs that with them at all times, but we should be as careful with this data as we're careful with money. You know, you generally wouldn't leave a tenner lying around on a table and walk away from it. We shouldn't be leaving communication books or communication aids on tables and walk away from them. And the same thing is all the necessary, that is the data on there, all necessary. And if there's sensitive data, it needs to go through the relative channels. Okay, so that's our process. You might add to that, you might differ from that, but that's the way we do it. We also have, as you've seen on there, a loss procedure flow chart, which basically is informing all staff. If something gets lost, then bring someone up, report it to a manager, report it to the relevant person at that time of day, because obviously these things happen evening and weekends and the relevant person isn't always there. So it's who it's reported to, how it gets recorded, what's done about it. So this does bring us on to then the thorny issue of how all this GDPR legislation affects the individual concerned, the person who wants to communicate and wants to speak. And this is why I'm calling this a right to speak versus GDPR. It shouldn't be a competition, but we've got to consider these two things in balance. So I would say that anyone has a right to talk about someone, even if that person hates you. So if I've fallen out with my brother or my best friend and they absolutely hate my guts and they never want to see me again, there's nothing in law if I walk down the street and see them passing me to shout, "Hi," and shout their name out. Even if they don't want to talk to me, I'm still allowed to do that. So just because an individual doesn't want their photograph or their name on a communication aid user's device, they don't really have a right, I would say, under human rights law to prevent that. And equally, you also have a right to talk about someone who might need to be reported. So this brings us into the area of safeguarding. And this is more thorny, I would say, but it's also more clear-cut. If someone is doing something nasty to me and I want to report them to someone, but the only way I have to refer to them is through my communication aid, and the only way I can recognize them is by their photograph, because I can't read names, then I should have a right to be able to talk about that person under safeguarding legislation. So this was the issue that I had in my head when I was thinking about all this GDPR stuff. So what I wanted to know is, what does the ICO say about this? Would they back me up if I said, right, this person wants the names of staff that work with them to be on their device, but do I have a right to say to staff that they have to have their photos on that device? So I put this rather long email together. I'm not expecting you to read it all now, But essentially, it's summing up what I've just said to you about the right to say someone's name under human rights legislation, and it being critical under the Human Rights Act, being critical to safeguarding. So I'm seeking guidance, and they were excellent, the ICO, I have to say. They rang me back and talked me through the whole of what they thought about it, which I'm going to talk you through in a minute. And when we got to the end of the phone call, I said, that is brilliant. I'm really grateful for that. Please, can you send it to me in an email so I've got it in writing? And they did, or most of it, as we'll see in a minute. So what does the ICO say about this? Well, I'm going to run through the key points here, which you'll see highlighted in yellow on your screen. Now, the ICO said that organizations would not automatically be in breach of GDPR if they used AAC aids. They said ACC, but that's just a typo. If they used AAC with photos of relevant people on. So you're not automatically doing the wrong thing by putting photos on. It's good. It's the right thing to do for your organization. But they would need a lawful basis to collect this information. And so they suggest, if you haven't done already, or someone in your organization hasn't done this, you need to know what lawful basis means on behalf of their ICO, and you also need to know what legitimate interests mean. Now, obviously, all of this legislation is not going to be termed in AAC terms and refer to this, but it's what the law says. So you need to have a lawful basis for doing this as an organization. You're not just cowboys trying to do this, and you need legitimate interests. So if it was in the legitimate interests of the organization to process this data, then the organization would not need to seek consent from staff members to take a photo. So to me, there's an implication here, which is if someone comes to me and says, I don't want my photo to be on that person's device because I don't want them talking about me, I would instantly be asking why, because of safeguarding and all the things we mentioned earlier. Now, they might have really solid and legitimate reasons for not having that. You know, there might be some legal issues or they're fleeing from someone or something like that, why they don't want it. But that needs bringing up on a case-by-case basis. But as a general rule, then organizations don't need consent to take a photo and have it on a device. And how organizations decide to handle that is up to them, because that's employment law, that's not data protection law. So if the organization decides that this is so critical under safeguarding that we will refuse the person the job, then that's up to the organization. The ICO are saying basically that's your balls in your court. However, organizations still do need to comply with GDPR with these devices and paper in the usual ways. So as we talked about before, the minimum data possible is collected. So if you need all that stuff, you have to justify why it's considered to be the minimum, and that the data's only used for the stated purpose. So you can't take all those staff photos and say they're going to be used on a device, and then suddenly someone's appeared on an advertising for your organization that is popping up on the internet everywhere. Now, this is just a reminder that if personal data is being processed in personal or household activity with no connection to the professional activity of the organization, then it's outside of GDPR's scope. So I have heard the argument from some people that are saying, right, well, this device belongs to the organization, we lend it to them, and all of the stuff on it is their personal data. They only use it at home, they only use it away from our organization. It's not covered by GDPR. If you can justify that and absolutely solidly justify that, then fine. But I think it's a bit grey, because generally, if you are lending a device to someone, you're also responsible for what goes on it, and you have a negotiation with that individual as to what data goes on it. So if the individual and the family and the carer are deciding, and they do that fully independently without your involvement, then great, it's not covered by GDPR. But if you've got a role in putting data onto that device, filling the device as they've said here, then I would say you're still covered by GDPR and you still have to consider this. So this is back to what we said earlier. Procedures should also be put in place, making sure you know who's got that device, when they've got it, what I can do about remote wiping it, or making sure it's encrypted. This is another key one, that if the device is lost, you need to know whether it needs to be reported as a data breach. You don't automatically have to report every breach to the ICO or what you consider to be a breach. On their website, they've got a tool that goes through, you answer a key set of questions, and it tells you, yes, you should report this, no, you shouldn't report this, or you should seek further advice, as well as they've got general guidance on what considers a breach. So don't jump the gun. Make sure that you find out before you start putting in a report, because you may not have to. So you can also ring their helpline, which is on their website, for specific advice. Now, this is I trust them on this as well. It's an anonymous helpline. You can ring this up, the helpline, and they don't record the calls. But even if they did record the calls, you don't have to give your name or the organization. You can just state the situation and what has happened, and they will give you advice, and they will be very helpful and tell you whether you need to take it further. So that's well worth knowing, that if it's not you, but whoever's responsible in your organization for following this sort of stuff up, they can ring and get advice first before they have to take it any further and spend a lot of time looking at it. Also in the phone call, now this was not written down and repeated in the email, so I'm assuming it's kind of off the record, but I'm sharing it with you anyway. The person I spoke to said the ICO is very unlikely to take action against an organization which is supporting someone using AAC. They said, I can't say categorically that they wouldn't, but it's very unlikely. So they recognize that organizations providing this level of support aren't businesses. They're not generally in it to make loads of money. They're not trying to cheat people out of their data. They're not trying to lose any of this data. They're doing it for with the great intentions. So she couldn't say categorically that they wouldn't, but she said it was very unlikely. However, you still need to do the right thing, because even if you think, oh, we're all right, then they're not going to prosecute, they still will be asking the questions as to what you've done, what processes you had in place, whether those processes were followed. And if you can be shown to have those processes and to have done the right thing, they will go, okay, thank you very much, or that's in likelihood. However, if there's data losses and you don't follow the process, and that happens a few times, they're suddenly going to get very interested in what you do. So you still need a lawful basis and legitimate interests. You have to be able to justify that. Think about minimum data possible. Think about whether it is really necessary for all that to be on there. Think about how you're going to prevent the loss of that device or of that book or whatever it is in the first place, so you don't have to go through a painful process. And then once the worst happens and something has been lost, what's your procedure? Have you got that in place before it happens, ready for lost data? You also need to report any breaches. So even though it sounds like it's a really involved process to report those breaches, then it's going to be worse if you don't do the right thing. So if you don't recognize this guy because you're too young, or you've never been to school and had a history lesson, then this is Richard Nixon. His problem was not that he did something wrong, although that wasn't great. His problem though is that he tried to cover it up afterwards. So we need to learn a lesson from his mistakes. If you experience a data breach or data breaches and you don't report them, and someone finds out later on and the ICO get to hear of it, that will be worse than you reporting the data breach. Part of the ICO's role is to measure how and where these data breaches happen right across the country. And so covering it up is really limiting their role. So make sure that you don't try and cover these things up. So to go over it again, make sure you put your procedures in place, get all this stuff buttoned down, and you need to follow them. And not just you, the person who's listening to this, but making sure that everyone in your organization who's got any responsibility for this AAC data knows what the procedure is and knows how to report and to follow those procedures. Okay, so that's it, really. I'm hoping that was a bit more interesting than the title might have made out. Anything with GDPR in it tends to send people to sleep. I'll just give a couple of minutes if you've got any questions to fire them into the box, and I'll see how well I can do with that. So we've got one already from Luke. Okay, how were you able to identify the exact number of individuals affected? Well, that was surprisingly easy, Luke, because although it is a very good question, because the individual had the photograph and the name of all the people affected on their device, we knew what was on there, but we also had a backup of that. In this particular case, it was Grid Player on an iPad, and therefore it had to be on a version of the Grid before it got ported out. So we had an exact copy on what was on there. But that does bring up a very good point, which is to make sure you have a backup of all those devices and a recent backup. If you create the language pack on the device, then you have to make sure that you back it up so that you know if the worst happens, what photos were on there at the time it was lost. Not 2 months ago, not 2 weeks ago, but ideally, weekly backups should be necessary. Okay, Scott, will there be a download of the slides? Yes, because there's lots of links in there, I'll make sure that everyone who's registered for the webinar gets a link to be able to download these slides, and then you can just click on the links and they take you directly to pages on the ICO's website and things like that. So any further questions? If not, oh, hang on, sorry, one coming in. So we have some students who bring their own devices into the setting. This is their primary method of communication. If I'm the person who edits the info on the device, okay, so a question, thank you, Rebecca. If you're the person who edits the info on the device, but it belongs to the student or the person that you're working with, how does that work in terms of GDPR? Well, it's a bit of a grey area, Rebecca, to be fair. Now, obviously, I'd bring you back to my first point that you need to follow best practice. However, it might not be just you who's doing that editing. If that person comes to you and they have, I don't know, an external SLT and someone else and family edit and things like that, you've definitely got a responsibility for that data. If you are taking a backup and you store it on a machine or a server in your setting, then once that data's on your system, you've got a responsibility for it. When it's on the device, probably strictly speaking, legally, it belongs to them, it's theirs, but you have to probably, in this case, I would say you need to make sure you had the permission of the individual to make those edits, or you have permission of someone who makes best interest decisions on behalf of that person. And that again is into a totally another grey area about best interest decisions and things like that. But in terms of GDPR, strictly speaking, it's their device, it belongs to them. It shouldn't be covered by GDPR. You shouldn't have to report it in the event of a loss. However, if you'd saved a backup to your laptop, say, and then your laptop got stolen and it had that data on it, you would need to report it. So it's subject to the situation that, or rather it's subject to where the data ends up. Strictly speaking, no, but I would still follow best practice, and part of that best practice is making sure that person's given you permission to edit that. Otherwise, you could be held liable for it. Okay, right. No more questions coming in, so I'm going to draw this to a close. You've got my the TechAbility email there on the screen and the website. Please fire in with any questions that occur to you after the session. And thank you very much for attending today.